Pro-XRP lawyer John Deaton has shared evidence showing that William Hinman, former director of SEC's Corporation Finance, lied under oath during his deposition in the Ripple lawsuit. It is worth noting that the deposition happened on July 27, 2021. In the transcript from Hinman's deposition, Ripple's lawyers asked the former SEC official whether he communicated with anyone outside of the SEC about the substance of his June 14, 2018, speech before he gave it. Responding to the question, Hinman said he did not discuss the substance of the speech with anyone outside the SEC. Attorney Deaton highlighted his response as false. Per Deaton, Hinman's emails showed that he informed his colleagues on June 4, 2018, that he would meet with Ethereum's co-founder Vitalik Buterin to gain more knowledge about Ethereum. Deaton asserted that Hinman and Buterin met on June 8, 2018, less than a week after the former gave the speech, where he declared Ethereum as non-security. Reacting to the development, prominent XRP community member Ashley Prosper noted that Hinman definitely lied under oath unless he wants to claim that Buterin is also a SEC staff member. Hinman's emails have continued to suggest that someone influenced Hinman to give the speech. At first, Hinman titled his first email while drafting the speech the Ether speech. He also blatantly ignored the warnings from top SEC officials about the confusion his speech might cause in the market. Some SEC staff warned that the content of the speech was divorced from Howie Prongs. Despite these concerns, Hinman gave the speech. Meanwhile, Ripple is already making efforts to uncover the mysteries behind the controversial speech, especially who or what influenced Hinman to give the speech. Please, do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. In a recent Twitter exchange, members of the XRP community sought insights from Marc Fagel, a former lawyer and SEC functionary, regarding the ongoing case between Ripple and the SEC. In particular, one of the community members questioned whether the watchdog would risk a trial against Ripple or opt for serious settlement talks, considering the potential ramifications for their broader crypto-related lawsuits against Binance and Coinbase. Fagel responded by stating that while a settlement would not establish legal precedent, it could potentially have significant implications. However, he expressed doubts about the likelihood of a settlement, noting that if one were to occur, it would probably have happened already. Fagel further mentioned that the impact of an injunction on future XRP sales remains a contentious issue. Fagel's stance echoes his prior statements, wherein he predicted an imminent ruling in the SEC's case against Ripple. He further noted that a recent unsealing order by Judge Torres implied that the court had already determined its forthcoming ruling. When asked if Judge Torres' decision to unseal certain documents suggested an intention to avoid a trial, Fagel refrained from making speculative assumptions. However, he pointed out that the unsealing of materials, such as the speech materials, which would typically emerge during a trial rather than in summary judgment, implies that some aspects of the case are likely to proceed to trial. Before I continue, I want to tell you something about DexPool. It's a self-composed liquidity provider, known as a market maker. It's like someone lending their crypto assets to a platform to help with the decentralization of cryptocurrency trading. In return, you receive rewards with fees generated by trades on that platform, something many consider a form of passive income, and you can get it if you use DexPool. Important to clarify that anyone can add liquidity to decentralized platforms such as Uniswap, SushiSwap, etc. through DexPool. DexPool has a welcome special sign-up bonus, which you can claim as long as you use the link provided in the video description. This bonus consists in getting up to 100 XRP. It is a 10 days liquidity bonus. The offer is limited. When you make a deposit, you will receive this bonus. Furthermore, over the weekend, XRP experienced a positive price movement as cryptocurrency enthusiasts celebrated Binance Exchange's recent victory against the U.S. Securities and Exchange Commission. In addition, the perception of the financial regulator as a common adversary has fostered a sense of unity among the crypto community. In turn, this led to XRP's upward trend in the past 24 hours, making it one of the few cryptocurrencies in the green heading into the new week. This optimism has been reinforced by ongoing discussions regarding an imminent ruling in the Ripple versus SEC case. Ripple's price movement has also turned bullish after hitting a low of 45 cents on Friday. This resulted in the weekend sparking renewed confidence among XRP holders as the remittance token's legal battle with the U.S. financial regulator draws closer to its resolution. Trading at 48 cents, XRP's price has maintained its bullish streak since yesterday when Judge Jackson granted permission for Binance US to continue operating in the United States. Consequently, CoinMarketCap indicated that the remittance token saw a 0.52% price increase over the past 24 hours. The altcoin's price is also down by more than 80% since reaching its all-time high of $3.84 in January of 2018. With the 100-day exponential moving average, EMA, at 46 cents now acting as support, XRP has entered a recovery phase as selling pressure subsides. If buyer momentum continues to increase, Ripple's price has the potential to surpass the 50-day EMA at 48 cents as well, which would open the path for a potential challenge of the resistance level at 49 cents. Dry sustained buying pressure could even push XRP towards the lower boundary of the supply zone at 52 cents. This supply zone may be followed by a sell-off from traders and investors. However, if buying interest remains strong, XRP's price may break through this zone and reach the resistance level at 54 cents. Such a move would signify a notable 12% increase from the current price. The upward movement of the Relative Strength Index, RSI, on XRP's daily chart supports the optimistic outlook for XRP's price, indicating a growing momentum in favor of bulls. On the other hand, if early profit-taking occurs, it could disrupt the upward trend, leading to a potential drop below the 100-day EMA. Now to the big question of the day: were the Ripple executives reckless to have distributed XRP the way they did? Please, do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. In a tweet on Saturday, crypto law founder John Deaton stated that no reasonable jury would rule that Ripple's executives Brad Garlinghouse and Chris Larsen were reckless in distributing XRP. The pro-XRP lawyer made this known in response to a recent interview by Ripple's general counsel, Stuart Alderete. Recall that the SEC sued Garlinghouse and Larsen alongside Ripple in December 2020, alleging that the execs were reckless in allowing the company to distribute XRP the way it did. Commenting on the development, Alderete said before the SEC can establish recklessness, it needs to prove that Garlinghouse and Larsen knew the law or recklessly disregarded it. He added that Ripple has confirmed that the Securities and Exchange Commission made an outrageous allegation against its executives. We've now confirmed that the SEC made an outrageous allegation against Garlinghouse and Larsen because, at best, the SEC was debating internally what the law was. At worst, they knew what the law was and distorted it to create this confusion, said Alderete. Reacting to the remark, Deaton said the regulator sued Ripple's executives because it was being the bully it loves to be. Although Ripple provided details of every XRP transaction, Deaton claimed the SEC still went through the bank records and credit/debit card statements of Garlinghouse and Larsen in search of incriminating evidence. Attorney Deaton said the SEC used fraud-like terms in a non-fraudulent case to intimidate and pressure the execs. When you're innocent, the two executives did exactly what you do with a bully, punch in the face, Deaton added. It bears mentioning that Attorney Deaton has previously commented on the SEC's case against Garlinghouse and Larsen. Deaton pointed out that the SEC was still struggling in 2018 to determine whether XRP was being offered as a security. Recall that two different analyses were conducted by SEC's enforcement lawyers and a third party to determine whether XRP is a security. Both reports concluded that XRP sales do not satisfy all prongs of the Howey test. Notably, the Howey analysis on XRP by SEC enforcement lawyers was submitted on June 13, 2018, a day before Hinman's speech. Commenting on the development, Attorney Deaton said, if the SEC itself was struggling in 2018 to determine whether XRP was being sold as a security, could these two executives still be reckless in 2013? He added that the Howey analysis on XRP will impact Judge Annalisa Torres' decision on whether Garlinghouse and Larsen were reckless in not knowing that the crypto asset was sold as a security. So we come to the end of this video, guys. If you enjoyed it, please make sure you like the video, don't forget to subscribe and hit the notification bell. This really helps me with the YouTube algorithm. Also, you can help enlighten others just like you have been enlightened by sharing this video to as many people as possible. Let's get this news everywhere, guys. If you are a true cryptocurrency fan, don't miss any of our content. See you tomorrow to talk about the latest news that concerns us all as a community.